All right, very well. Welcome everyone. Sorry for the late. And welcome everyone for the Wareham Zoning Board of Appeal for tonight's agenda for, it is January 10, 2024. Happy New Year, by the way. And we are at room 320 at the Multi-Service Center, 48 Marion Road, Wareham, Massachusetts. I want to call the meeting to order. My far left, our member, Mr. Richard Semple. My far right, Mr. Troy Larson, Mrs. Veronica Devenese, our clerk, Jim Akabachi, myself, the chair, Nazi El-Khalasi, also present. Our commissioner, Mr. Paul Turner, and our town planning assistant, department assistant, Sonia Raposo. Okay, very well.
Department Girl Friday.
All right, we're gonna do the minutes 12/27/2023.
And is Ken online?
Yes.
All right, also we have Mr. Ken Buckland, our town planner, online on Zoom. All right, minutes.
I have yet had a chance to review the minutes. I'd request that we table this until the end, and, like, we can peek at them while people are talking to us. Ignore them or something, or look at them at the end.
I did have a chance to look through them, and I was just curious, there was just a question on a vote. Ms. Debonese joined us late, but there was a vote of 5-0 and then a vote of 4-0, and I was just curious if...
Which one is that?
I was just trying to get online to go to that.
You got a copy of it in, no?
I don't have a copy of the notes on me.
Pardon me? Yeah, you want to see it?
I got it here now.
Okay.
You got it quick, I might pick on it quick.
But anyway, it was just right after there was a vote of 4-0-0, after there was a 5-0-0, so I was just curious if we missed a vote or if, what happened on that one. But other than that, everything else looked good to me.
I don't know if he is.
Okay.
Okay.
Sorry, I'm just trying to do it on my phone.
You're looking, that's all right. We've got all night.
On,
No
that was
deadline on how
the,
late we can stay.
that was the Onset Bay Marina.
I didn't vote on that, and then I think, so it should have been,
Well,
You
I'm
abstained
just
on that
curious if
one?
it-
I didn't
there
vote
was-
because I wasn't here to hear the whole thing.
You didn't vote at all. You
All right,
didn't
so
abstain.
that's what it is.
There was something else, though, that I think, Naz, you did ask me, and I answered abstain, I thought, but,
We'll have to go through it.
yeah.
Never mind.
Let's
no good.
let's not let everybody sit here and watch.
We'll
us
have to
do
see, listen to the
clerical
tape.
work. We-
All right, very well. We're gonna go 45-23, Josh D. O'Leam for the special permit 2613 Cranberry Highway. All right.
Okay, I've viewed emails and written letters from Attorney Perry expressing that he personally has health issues that require him to request an extension.
How long do you know?
I think he said, I'm sorry, I did know, and I have it, I'm pretty sure January 27th. Let's extend it till the 27th.
24, you mean?
Pardon me?
January 24.
24?
Yep.
What's the decision deadline on that?
Oh, he also sent a letter today saying that he'll extend, that's where I got the 27. He'll extend the decision deadline till March 27th. That I
Okay.
remember.
All right, do we have a motion on that?
So I make a motion to grant the extension.
For D. O'Leam, 2613 Cranberry Highway till January 24. Do I have a second on Jim's?
Second.
Can I make that January 24th or as requested by Attorney Perry?
We can be, no, let's,
Okay, I don't know
We'll
what,
see what-
I'm not certain of the two.
okay, for that specific time, you mean?
Yeah,
All right,
yeah.
Are you looking for the date?
You look, no, I'm looking for his letter. He said a specific date he wanted it continued to, and I don't want to trust my memory.
Okay. 'cause
Sonia, you know what date?
Perry, did you know? do you
I read
remember
it
when-
last week.
You can't, you don't remember.
I don't remember. I thought it was the 24th as well.
Okay, then maybe
Keep
I'm,
it.
you know,
We keep it at 24.
oftentimes I think I'm wrong and it turns out I'm right, because I'm usually right.
We keep it until the 24. If anything changes, we'll give him that one-time extension.
Okay.
All right, so
And we're extending the time for decision till March 27th.
he did give us
He,
that.
he did that, he granted that, and I
All
just
right,
wanted,
very well. So we have a motion by Jim, second on that?
Second?
Second by Rich, all in favor, say aye. Troy? Aye. Veronica? Jim?
aye,
Rich?
Aye.
And myself, Nazi, aye.
500.
Okay,
Okay.
124.
4723.
47-23, new singular of 24 Brown Street.
You want the folder, or you want to just listen?
We just listen. Unless you guys want to look at it.
No, I'm good with it. You're good.
All right, Council, I think public meetings still open, and you changed it to a variance, correct?
This is correct.
And it's been publicized and all that.
Yep.
Okay, very well. Before we go forward, anyone in the public want to speak in favor or against this matter? I hear none. Go ahead, Council.
Yes, so at our last meeting, there was some question as to what relief we should apply for, seeing as the 10-foot extension to the tower that we were proposing would encroach into a setback into an abutting property by about 7 or 8 feet. We had applied for a special permit together with other relief that the board deemed necessary. The chair and others thought perhaps a variance was appropriate for that setback issue. In the interim, the hearing was continued, and in the interim, I spoke with Ken Buckland, who was interfacing with the town attorney, who I believe was in the hospital. But we talked through the Federal Spectrum Act as well as the local zoning ordinance, and we decided that the appropriate thing to do would be for me to amend our application to include this specific variance, and we have done that.
All right, very well. Let me ask you something, Council. You guys own, that your client owns the property or it's leased?
Excuse me?
Your client, New Singular, owns the property or who owns it? Still Deacus?
It's on a 99-year lease.
The tower company that we're leasing from owns the property. It's ITW Realty Trust.
Okay. And how long is your lease with them?
I believe 25 years.
All right. My question is, when they acquired that property, didn't they think they're gonna extend it another 10 feet in the future?
I'll be honest with you, I don't know what they were thinking back then.
All right.
I've seen all the correspondence between Buckland and Bowen. It doesn't seem like it's a major issue to other minds.
I don't see an issue, and you still gonna provide the town with the engineering letter that it says it'll show and
Correct.
demonstrate it will collapse
Yes, that was
in itself.
attached to our amended application.
All right, okay, because the commissioner will not issue a permit if it's granted without that letter.
Yes, and that letter indicates that the fall zone required because of the way the tower was engineered is actually only 107 feet, not 160.
Okay,
Tower's designed to collapse on itself.
Correct.
all right. So what do you think, Roy?
I don't think we need to beat it to death. I make a motion that we approve the request for the variance.
Well, let's go for discussion first. Veronica,
I have no comment.
Richard.
Is there any conditions?
Condition is
Then-
that they provide a
letter.
structure engineer that it will demonstrate that it will collapse in itself. If
Can we
there's-
set any conditions?
We can.
I drove by there today, and it seems pretty of an eyesore. Is there any way we can get some plantings put around there or anything on that end?
We
I
can.
mean, we're being asked to take it whether we like it or not. According to what I read, is that we can't deny it. So I was
No,
just
we can
curious.
deny it. We
Yeah,
can, it's a
here's the
variance.
problem. He's a tenant of the tower. We'd be putting the...
A burden on the person that's
on
leasing
on
it.
the owner of the tower. I don't know, Ken, are you online? Would you chip in on this? Can we put a condition on a
Of course you
subtenant?
can. It's not up to Ken. This is not up to Ken, it's up to us.
We can put a,
Of course, you can put a condition, not to mention the owner of the tower, the land or the
That's what I'm
property is
talking
gonna
about.
get more money for that, for going up another 10 feet, so. So
It
if,
just looked like an eyesore to me today. I mean, you got residents, you got a highway going by, it's got thinned out.
we
We're
could
being
do,
asked to approve something, I just was curious if we get to get it cleaned up a little bit, that's on my end.
could do, grow a giant all the way around it. Giant
You wanna-
greens,
do you want to make that an amendment to the,
whatever,
it
once
just-
we talk for, once we put it up to vote with the discussion, he could put the conditions, see if the board go for it. Right?
Sounds good to me, I just was asking, I mean,
yeah?
I think it's a good idea.
Go ahead.
I think it's a good idea if, I mean, I haven't driven by myself, so if you saw it and it looks like an eyesore, I think it's the perfect time to ask them to do something with the property.
I don't have a problem with that. I think it's a good idea.
Counselor?
Yeah, we don't control that area, so I can't agree to anything, but I could pass along your comments, or if you want a condition, the extent to which and what you're talking about, I don't have an appreciation for what you were considering. But if there's an area that needs to be,
We'll see what the board come up with, and your client has to comply. If they don't, they just, commissioner won't give them the permit.
yeah.
That may not fly his idea.
It's not
or
my
something.
client, so,
Okay,
but I hear what you're saying.
all right, very well. And you have anything before we close?
No,
Okay,
thank you.
motion to close?
My motion to close the public portion of this hearing.
All right, do I have a second?
I'll second.
Second by Veronica. All in favor to close? Troy?
Aye.
Veronica?
Aye.
Jim?
Aye.
Richard?
aye.
And myself, I closed. Now the wishes on the variance.
I repeat my motion to grant with the condition that the required engineering and letters appropriate be submitted to the commissioner.
All right, any other conditions?
And conditions of some greenery to spruce it up,
To
make it
all the way
bolder.
around
It's
with
gotta be,
giant
it
greens.
should, I mean, it's horrible looking.
Okay,
I mean, you got a bright yellow fence, you got a bunch of nothing around it, and fences and buildings, and
right, so with giant, 6 foot or taller, giant greens, 5 feet apart, all the way
Where?
around the perimeter. That sounds right?
you gotta hide something. I mean, the neighbors are just looking at it.
Arborvitae's or something?
Giant arborvitae, giant greens, that's what I call them, giant arborvitaes. 5 feet or taller, 5 feet apart throughout the perimeter. So that's the motion so far. Is there a second on Jim's and Rich motion?
I'll second.
Second by Veronica. All in favor of that motion, say aye. Troy?
Aye.
Veronica?
Aye.
Jim?
Aye.
Rich?
Aye.
And myself, aye. 500 with the conditions.
Okay.
Thank you,
very
Counselor.
much.
Thank you. All right. We move to Kelsey McKenna and Jonathan Delmeyer, 504 Main Street appeal. And that is Counselor.
Do we need that in front of, go ahead. Oh, sorry.
Still open, just remind me which one is that?
This is that's-
Oh, the one on the corner.
Yeah.
Very well. You still open, public hearing is open, please.
Okay, great. Well, I'm happy to report, we're working with the abutter.
Yeah.
So where this leaves me, though, is that I do want to leave the hearing open, because obviously it's not closed
All right.
yet. So we have a decision deadline, I think, by February 23rd. I don't think it will close before then.
Right.
So I'd like to just have it extended out, and then I can withdraw, but hopefully it's all settled.
Okay, I recommend we leave the public hearing open till,
You want to extend the deadline, the decision deadline?
Deadline, and
And
I
you want to
I
extend?
guess you could close, it doesn't,
no,
just give me a hearing date maybe in like
you will give
March.
us an extension for deadline, we'll give you an extension on the hearing
Perfect.
until
Second week of March, is that okay?
The
next year?
The 20th?
No, it's not gonna be enough for litigation. She won't.
No litigation, it's settling.
It's settling, you
Yeah,
sure?
so I need like 60 days, 45, 60 days.
All right, 1 second. Let's go to April 11.
Perfect.
All right, so
So 11th on the extended hearing, and what about the extended decision time?
Oh, I see.
she will write us one, right?
Yeah, I'll give one out after that. It should be all
30
handled.
days after that, something like that?
Ideally, we're gonna purchase the property
Right.
next door.
Let-
So we're
let's go-
working,
let's
working
get
with
a
the other
dis-
side, so.
We do decision deadline for April 26. Give us
Perfect.
2 weeks after that.
Okay.
Okay, very well.
Great, thank you.
All right, anyone on public want to speak for or against this matter? I hear none. All right.
Move to close the public portion,
No, we're gonna move to continue. We're not gonna close
or
it.
we're not going to close it? I'm sorry.
gonna still
Move to
open.
continue.
We move to continue until April 11, 2024.
Second.
10?
Second by
April 10th?
April 11, I'm very sorry.
Oh,
April
sorry.
11, 2024. No, sorry.
10th,
The 10th is,
it's a Wednesday.
Oh,
Wednesday.
okay, yes, yes.
The 11th comes on the 10th this
No, you know what, I'm looking, I'm leaving the 11.
Oh.
I'm reading my date, I'm leaving, so,
The Wednesday comes on the 10th.
right. So April, till April 10. So, do you have a second on that? On that motion to continue?
Second?
Second by Veronica. All in favor, say aye. Troy?
Aye.
Veronica?
Aye.
Jim?
Aye.
Rich?
aye.
And myself, aye. So we'll see you on April 11.
April 10th.
April 10 again.
On April 11th, you'll be going away.
All right. I guess I'm looking forward for
Looking
that.
forward to that
Yeah.
one, huh? That date's etched in your mind.
It's getting up. April 10 continued.
South Boulevard, is that you again?
All right. 43 South Boulevard, 51-23. Just give us a minute. Let me take some notes so it doesn't go all over the place.
And there was another follow-up letter from the attorney in opposition. It's in the folder.
All right. 49 dash,
I didn't receive
sorry, 51-23, Karen DiMichele, appeal on 35 South Boulevard. Public hearing still open. It's yours,
All
ma'am.
right, great. Attorney Jillian Morton, 184 Main Street. I'm going to pass out what I submitted, just, I don't think it was printed. I have it. Yep, awesome. So it's just my additional letter.
Thank you.
Thank you.
And did you say there was another letter in opposition that was submitted on
There
this
is, I
one?
only have one copy of it. If you want to see it right now, if you want to be able to look at it, I don't care. It's up to the chair. Do you have a problem sharing it with her?
No, it's fine.
What's
You'll
the date on that one?
It'll
Was
probably
that-
come to you by email. Sorry. You're younger than me. By a couple of weeks, anyway. I would have got up.
All right, where did we leave it last time?
So if you recall, this is over on South Boulevard, and it's a property that we had a notice violation for poles and a curtain that was up. Only one of my clients were there about 30% of the time. How we left it was looking at possibly going for a variance for that. And so we're in a position now, which we actually discussed it, and we wanted to provide you with some more documentation, because I think there was discussion about the bamboo and about the canopies, you know, what can we do in regards to this privacy? That was the case with the two neighbors, and that are in other litigation, civilly and criminally. So right now, we're still pursuing this appeal of the notice of violation due to the importance of the safety and privacy. We're in the middle of winter, so we're not able to get, we've talked to Clive Olson and other landscapers to look into abrevieties, other things that might be suitable. So we do believe that it would be best for my clients and not hurt the town to have these in place until we're able to maybe try to do something different. So I know there was a concern about electrical. That was the next day handled. So I don't know if Eversource was called but that was one where there was a pole near the wire. I know that was a concern of yours. And the curtains are not up. So what I provided for you was pictures, just so you could see. There is, the first one really shows the towering structure. So this was what was approved through the zoning board, I think 2021, this new build. And my client's property is right here. You can see that they have a fence and on the side, as well as the bamboo, which has grown. Now the question is, and people might say it's going to grow higher, it's going to be able to block the view. We actually put underneath, when they installed this, a plastic mesh to make sure that it didn't go onto the neighbor's property because of the situation. So it's stunted. So it's not going to be able to grow higher than that. Another piece that you had talked about was a canopy. We have the largest canopy that we can attach to the actual building. So there's a picture that kind of you can see looks like at the end.
We saw it
A
3 or 4
canopy,
in
there's a
there.
few of them, yes. You see this canopy, and then, so there have been a lot of things that we've tried to do to mitigate this. And now we're in a position that we hear that the poles are not something that maybe thinks a violation, but in order to protect our rights and to be able to have the privacy, the idea would be just when they're there to allow the curtain up while they're there. And if they were able to find a different structure or abrevieties that are up high enough, that's going to take some time. So we can't do any plantings in the middle of January or even get those type of plants at this point. We're also looking into alternate structures. The very last page of your documentation, or second last page, just kind of shows one of the different structures. It has 4 sides. It's kind of like a pergola with the shades on top. Now, these are very expensive, but this is something that we don't want to necessarily buy and then get a violation because it's a structure too close. We're in a predicament that we're trying to work as much as possible, and we've done all these steps. So in order for us to move forward, we still need to continue with the appeal. So it would be continuing to ask for the appeal of the notice of violation, whether you would continue it till the spring or something like that. Right now, like I said, the tarps are not, the curtains are not up, so it's not anything in the way of a danger or anything like that. So that's where we're at.
Yeah, I went look at it myself, and I think awning would work. I personally very against these high fences, especially in that area. Start putting fences between these houses, that tight as it is, look horrible. Giant abrevieties, if you get 10 footers, they'll grow before you know it. They only get 50 feet, they need 10 of them. And if they get 10 footers, they'll grow quick. Even if you have the fiber mesh towards the neighbor, they'll still grow crazy. They water them, they grow, and you have to find alternative with the awning or something. I'm personally against those column, those oak, whatever you call them, mahoganies, and especially that top they put in, that looks horrible. And in onset, it is what it is. Houses are close to each other. You never know, maybe in the future, your client will come and wanna go 35 feet like next door. So, which is okay. But that's my thoughts anyway. Troy?
I don't have anything right now.
Okay, Veronica?
No comment.
Jim?
I have to concur with the chair that I'm not in love with the idea of encouraging this practice of this situation to continue. I think both houses are built according to the Wareham bylaws. I mean, no, this is not New York City or Boston, but there certainly are places other than Wareham where you can look out your window and look in your neighbor's window. I don't think the cry of privacy is a legitimate reason to have a violation of our bylaw. That's my personal opinion.
Rich?
I don't have anything.
Nothing? No. Okay, anyone in the public want to speak in favor of this matter? Anyone against this matter? Okay, I hear none. So,
I would I'd be willing to continue, I think we left it the last time that the canvas or the tarp or whatever it was that was an attempt to create privacy not be put back up until an alternate method or a decision or some information came to us. We gave them time. I think what they're looking for is more time.
For why?
And, yeah,
So either we're gonna uphold the commissioner's decision or overturn it. That's what we're here for.
yeah, I personally tend to think that no matter what they come back with, we're gonna tell them they have to go down.
Right.
So, I don't know.
Okay.
Or what we're seeking is some time, though, to be able, we can't have anything in, arborvitae's or anything in that sort installed right now.
Right, we're not asking you,
Got
but you
10
could
foot.
move these 4x4s.
But you've agreed not to put the canvas up, and if we say you don't put it up for a year, what good is leaving the posts up for a year if a year from now we're gonna say, take the post down? Let's just, rip the Band-Aid off.
We can continue the hearing open, so there isn't these violations that are out there until we're able to have, in the spring, some time to put something there. I mean, that's why we're in front of you, to try to get some guidance. If you look at that pergola at the end, that on the cheap side, like 15 grand. So it's not a cheap buy, and then you have to install it and have a structure over, and it's going to be permanent at that point. It's not gonna be something that's only up there
Right,
30%
you're
of
gonna
the
need a
time.
variance for that too.
Well, that's the thing, right? If there's a structure on the other side, it's gonna be close there. It feels really hard to be in a position where something so large is allowed, and then, it's not just privacy. If you read through the
What
documents.
was it I'm sorry, what was it so large that's allowed?
The house with the decks
Oh.
facing downward, and I just want to remind you about, it's not just privacy, it's safety. I mean, there's criminal and civil litigation in the affidavits. You read the language and the behavior that was with the neighbors to my clients.
Yeah, you gotta go to cops to deal with that, not the cops or the courts. I mean, if they harassment and stuff, the best bet, call the cops, file a suit, I don't know, go to court, get a 93, what do you call it? Stay away from me, whatever, that restraining order.
Restraining
Yeah.
order, yeah.
Yeah, so I mean, they're trying to say that this is some sort of spite fence, but it's really, for us, and I don't think you've mentioned that you think it's that at all, that it's for our privacy. You understand there's a giant structure overlooking their backyard. The pictures show from like the bathroom, you see right into the deck.
I totally understand what you're saying, Carl. I don't think they do in a spite fence either, but I can personally, if the board give it to you, I can personally agree, start putting these high structures, start separating buildings and us. It's a community, everybody talks to each other very close. I don't know what to say.
So you're saying that though, if there was some sort of canopy, or in the last page of your packet where you saw that it's looks like a giant pergola with these shades that come down, that would have to be a variance because it would hit the setbacks?
I think, Commissioner?
Yes.
Yeah, I think so.
A retractable awning, if it
No.
No,
if it
this is a
extends
perg-
out,
They're talking about a pergola.
okay.
Yeah, you
They
see,
already have a retractable
So-
awning, yeah.
But you need no permit to plant a bush.
No,
Not at all.
Pardon me?
no.
Not
Not
at all?
at all.
Okay.
the difficulty.
So,
oh,
can
You need a
can I
permit
ask,
to
what
put up
is-
a light post. Can I put a light post on my property line to
No.
put a light into my yard?
No. Not over 7 feet.
Correct.
Becomes
Treat it like a fence? Okay.
so, through the chair, I mean, is there, to be fair, can we extend it, pull the, in favor of the
applicant.
applicant for, just for a while? I mean, again,
while?
listen, to give them a chance. I mean,
Chance for what, though? That's the question. I get his
I'm just
point.
trying to be fair all around. I
I
mean,
get
it's
that. I
not fair
understand.
that that big albatross went in the middle of everywhere, and it has a reaction from everything when you do something like that. Yeah, it makes some neighbors mad. Some people can't stand the blanket being up, but quite honestly, you can't stand seeing that big, huge house in the middle of a nice, quaint little neighborhood either. I mean, it's got its pros and cons all the way around, so I was just
How
trying to
long
be
do you
fair.
want to give it for?
She's asking the time to get them to be able to put something in, I don't
Give me a
know.
date, June, July,
On
May.
that discussion,
July 20th.
is that big house built beyond the bylaw? Does the height?
If you want to go by it and look at the
No, I've
footprint and
gone by,
everything, so,
But is it,
it's just-
is it a
it just-
lot- is it, did they get
it's
a
just my
variance
feel-
to
it's
put
my-
that in there, or was that in there by right?
I just want to,
I don't know.
I just want to be fair, that's what all
I
I'm
know,
trying
I'm
to do.
not trying to be unfair to either side.
All right, we put it to vote. So he's suggesting we could make, what do you need?
Make sure you're listening or you're speaking to your microphone.
Yeah.
Okay.
He said he could put a condition. You could make a motion, actually. July 20, you said?
Yep,
Okay, when we close, everybody speak their piece, and we go from there. Okay?
Yeah, I'm not opposed to his theory. I'm solely for the point of discussion. If the people with the big canvas up wanted to put a house of equal height, and the house behind it was of lower height, we would have no sympathy if they said you're blocking our view, because they don't have a deeded, if it's there by right, it's there by right.
I understand, but right now, it's a different situation. Let's do it by vote and let the vote
No,
take
I'm
its
with you. I
its
just-
course. All right, that being said, Counselor, anything before we close?
Just clarification, if we're allowed the continuance, what would occur then if my clients are there, that the curtains would not be able to be up at all?
If Mr. Richard Sample, if his motion flies and you got a vote, you'll use it.
When we're there, I mean, that's the other
Until-
thing. 30% of the time they're up.
July?
You're suggesting they're allowed to
20.
use the canvas?
Yeah, I mean, that was the sense of having it,
Yep.
right? Right?
exactly,
Until July 20, it has to come down.
yep.
By then, they should have planted trees and everything. I think that's good.
Can I ask, in regards to if there was a structure, again, putting $15,000-$20,000 into a structure, what the board would think as regards to a variance for that?
Until it comes before us, I can't, it's not before us to discuss. Then you
Right,
see
it's
the.
related, though,
Huh?
right? It's related.
We can't vote, I mean, you want everybody's opinion?
The flavor of the board.
What do you think if they put a gazebo? Troy?
I would not have a problem with this.
Veronica?
I have a problem with giving variances to try and get privacy from a neighbor they don't get along with.
Jimmy?
I'd possibly abstain. I'm not big on the idea. I think that there's another solution that voids the need for a gazebo. So,
Right.
if they came back and said, oh, we found out in order to get a 50-foot arborvitae, we need to dig a hole that's so big our house will cave in, well, then they'd have a reason to ask for the gazebo. But right now, I see a solution that doesn't include a
I mean,
gazebo.
I do agree with Jim. I mean, these rears, these little backyards, we start filling them up with gazebos. Everybody don't like the neighbor. Before you know what,
Might as well change the setback on the bylaw.
what do you think, Rich?
I've already said what I think.
No, regard, and the gazebo. I know.
On the gazebo? I don't know, I can't,
Well, you
I'm-
got three
I'm
against
torn.
you anyway, so I ain't going nowhere, I guess. So, all right, that being said, anything else before we close? All right, can we get a motion to close?
Motion to close the public portion of this hearing.
All right, do I have a second on that?
Second.
Second by Troy. All in favor, say aye. Troy?
Aye.
Veronica?
Aye.
Jim?
Aye.
Rich?
Aye.
And myself, Nazir, aye. Now, wishes. First of all, on the violation,
Okay, I'll make
are
a
you
motion.
gonna uphold or overturn the commissioner's letter?
I move we uphold the commissioner's letter and that the posts be taken down and the canvas not be used anymore.
All right, that's the first motion. We'll get to your motion. Okay, do I have a second on that motion?
Can we
No.
add,
Okay, you could discuss it.
so can we add to the motion?
Yeah, you could add a
Rick
mo,
had talked about that we put that date to July.
well,
that
if,
they get removed
if this motion don't fly, we go to his motion.
I'll withdraw my
but-
motion if you want to make a different motion, or if you want to make a different
Right,
motion.
good
In
idea.
front of my motion,
Go ahead, withdraw it.
I withdraw.
He withdraws, good
That's
enough.
So I make a motion, to extend and give them till July 20th to come up with a solution, and then the posts come down.
No, what happen if they don't come up with solution? The posts come down, period.
At 20th, everything comes down.
All right.
So this is why I didn't think you should withdraw your motion, because we have to talk about the letter, and whether we're upholding it. So by upholding it, but putting a postponement on the removal of the poles till, is that possible, till July, so that we get both things? Right, because we're not talking, we have to decide on the letter.
Or we have to decide on the letter. What we could do, we'll overturn the commissioner violation, and we'll vote.
We could support that there's a violation, but grant the applicant until July
Does that work?
20th to cure it, with no penalty between now and then.
That seems cleaner to
Now we're
me.
upholding his decision,
Okay.
and we're giving them time to correct the situation.
Very well.
And the neighbors all get to look at a dirty canvas until next July.
Okay, let's let somebody say it nicely, so
Somebody say it nicely.
legally, nicely. Did you get that motion?
The motion to accept the commissioner's violation letter, and then to extend until July 20th, and then after July 20th, it comes down.
Comes down whether there's a solution or not. That fair?
Yeah, so that they can put them,
They could use it.
up when they're
We're
there.
voting to uphold his decision that there is a violation,
And
but
to
we're
state
giving
any
your client until July
20th.
20th to cure it. On July 21st, the 300 or 350 a day penalty kicks in if it's not down.
Okay.
Is that
Correct.
what you intended?
Yes.
We don't care
100%.
what solution they come up with, that's moot to this conversation.
Right. Okay, so we have that motion by Rich. Do we have a second on that?
Second.
Second by Troy. All in favor, say aye. Troy?
Aye.
Veronica?
Aye.
Jim?
Aye.
Rich?
Aye.
And myself, Nazir,
Make
aye.
this decision? Do you need
Well,
notes on that?
I'm sure Patty's reading
Patty?
it, right?
Okay.
Okay. Very good. So this is your decision, council. You can vote. All right, we're gonna move to discussion for rules and regulation for special permit, and site plan review and special permit. We'll get back to that. We're gonna move to public hearing 21-23. Angela McCowan, reconsideration of a former application, 386 Main Street.
I want to get these all back in the correct folder. I think 2 or 3 of them are enough, though. What was that? That was 51.
That's a motion of consideration. I don't think there's a site plan or anything.
What's
Is
that?
is that a file on it?
Say it again?
Is there a file on it?
Yeah.
Oh.
5123, yeah, that was, I just didn't pass everything out because we had already seen it already, and I knew there was gonna be new evidence, so. It's like counting the same thing twice. Where are we now? This is, number 5 is discussion on the vote on the rules and regulations. I move that we table that to the end so that other public hearings don't have to sit through our discussion on rules.
Correct.
So there is a letter to go along with 21-23.
Yes. All right, is that a file on that matter, on that 386 Main Street?
Yes, 2123. Yeah, here it is. This is a new one, right? So we gotta read this in. We already made a decision here, I think, and now this is a new.
Right.
Okay. Zoning Board of Appeals will hold a public hearing on January 10, 2024, at 6:30 PM in room 320 of the Wareham Multi-Service Center, 48 Marion Road, Wareham, Mass. 02571, to reconsider petition number 21-23 for a site plan review, special permit, and a variance from the requirements of Article 3, Section 320, and Article 15, Section 1520, under the Wareham zoning bylaws, to Angela McGowan, trustee of 398 Main Street Realty Trust, care of Attorney Jillian Morton of 184 Main Street, Wareham, Mass., proposing 3 duplexes to an already existing 4-family located at 386 Main Street, Wareham, Mass., which appears on Assessors Map 61, Lot 1079, in the Wareham Village 2 zoning district.
Right, Counsel.
Great. Attorney Jillian Morton, 184 Main Street. What you have before you is reconsideration for my clients, who, if you recall, the vote on this one, which is attached in my initial submission, was 3 yes and then 2 abstaining. We are able to reconsider this petition and put this in front of you on the basis of new information. So our understanding in rewatching the hearing was that the 2 abstained was due to a question regarding the T-shaped parcel and the easement. So we're in a position now that we are going to be owners of the 1/3 fully outright. So as far as questions of that ownership and things, it's a new situation there. We believe that the project is best for Wareham, that it's been vetted through peer review. The last review from Phil Cordero said there was no issues. Our engineer had it all approved. So I think how this was decided and the decision itself just says it didn't have a supermajority, right? So there was no actual reasons on why, other than what was spoken at hearing. We do believe this has been vetted and gone through extensive peer review, that the opposition has had time to state their place in the project. And we reiterate that, and you did as well, that this is something that by special permit, there could be 14 units out of a big structure, right? So, but we're looking to pursue these duplexes, and we really do think this new information, the fact of that we will have ownership of that, is huge for the case. I do want to bring up, because one thing with us is that we're very transparent. So I know that there has been a letter from the commissioner regarding issues with the main house. So I want to be upfront about that we're working on that, that we spoke to the engineer, and we don't have the revised plans for that yet. But there's nothing we're trying to do, outside the scope of giving that information to you. I don't have it yet. So I would ask that, I know that that's something that's on the same parcel. So, but tonight will be limited to regarding the reconsideration.
All right, so you're saying under MGL 40A Section 16, you have substantial changes or evidence in the case. By then,
Yeah.
the board have the right to grant you.
Yeah, and I'll address, I did receive late this evening opposition from an attorney about saying we don't have the right to be able to do this. And he named certain reasons procedurally why this wasn't correct. Now, this actual section, in my opinion, allows me to go under preliminary business and ask you to reopen it. What we decided was that this was such a case that the abutters want to know about, that we filed a full separate petition. So I have all the green cards about all the notices. So we went above and beyond to be able to make this procedurally, letting people know this is what we're doing.
All right.
So,
I am aware of that letter, and I'm aware of Section 16 on MGL 40A. So you're saying the new evidence is, you guys want to concentrate on this? This is what's going to base if you're going to reopen or not. The new evidence on this matter is the legal part that you own, that's your new evidence?
yes, because, and again, I got this letter late, but the research that I could do, that everyone has Mark Bobrowski book, but regarding, how big does a change need to be? And it says that you guys can give weight to differences which are minor. And my opinion, the decision was not granted because of this. So now we have the evidence and we've moved forward. My client paid the back $6,000 taxes. We've negotiated, we've worked with the estates, which is a huge title problem, but we're working on it. So, you know, we've really gone above and beyond to try to move forward to make sure that this is done correctly. So I do believe it is new information that's pertinent to why you would agree to this, because the main contention was the T-shaped parcel, overburdening this parcel that, and who owned it, right? So now, we're in a position now to own the 1/3.
All right. No, on the same subject, your client has a cease and desist on the property, and you're aware of that?
Yes, that's what I'm discussed, and I spoke to the
But
engineer.
what was that cease and desist? What did the client do?
So it was the third floor up there, and it was finished out. So what had happened throughout the process is the new plans weren't given to the building commissioner. Like I said, I don't think this is a forum to discuss that, because we're working on it. We just got the letter on the 27th.
Right, but
so
I
we
finished
still
that,
have-
so he added a unit.
Yeah, but we're working on rectifying and being able to give the information regarding the plans.
Apparently, I mean, you guys see that letter? I mean, there's a major violation that he just raised.
But we're not here on this.
I understand, but we can't.
And I'm happy to continue it until we can get the information. Our engineer was out, and that we spoke to him, and he should have the information to be able to provide.
I'm gonna ask the board, did you see this letter? Right, okay, what do you think of the whole matter?
I was kind of surprised when I read it,
Okay,
because it happened.
and what do you think of reopening the hearing? Reconsider it?
On the four-family or on the
No, the whole project.
whole project?
Do you feel as though there is substantial evidence, new evidence to reopen?
Yeah.
Yeah, okay, Veronica?
So regarding the letter, I think that it changes what's before us for the permit, because what's before us, if we were to reopen it, would be for 10 units. This would make it 11, because they have one that they're adding.
Correct.
And then the other thing is, with the parcel, I mean, it is, I think, a change where there's an ownership change of the land that was in question, so.
All right, Jimmy?
Before I comment, I want to make sure that it's on the record and clear to the board and to anybody listening that I am within the distance of this property as a property owner, that I was on the required list of notices of abutters and abutters to the abutters. If the applicant or any board member feels that I cannot act with, without prejudice or with prejudice, then I'll recuse myself. I don't feel the need to recuse myself, but if anybody present or on Zoom feels I need to, I shall.
Board, are you okay with him?
Yeah, but just a question, if they're in violation, can we grant anything?
That's what we're gonna discuss.
Okay.
But you okay with Jim staying?
Yep.
I have no problem,
I
Veronica?
don't have a problem.
Okay, very well.
Would
The
you-
applicant,
Would
She's
you
fine.
mind stating that in writing for the file, just so that?
Yeah.
Thank you.
okay.
That just, and I'm kind of, then my comments on this are that regardless of new information, Veronica makes a point that we made a decision based on 10 units, and now we're potentially facing 11 units. The application that's already been decided, in my opinion, is a little bit tainted, and it leaves a shadow over the whole thing. I don't know whether to reopen or not reopen. As you know, I voted in favor previously. I don't know how I would vote now.
Rich?
I'm good with it right now.
Good.
I don't have any comments or anything to add.
All right, we're gonna move to the public. Anyone here in favor of this matter? Anyone against? Okay, sir, come forward.
Just very briefly.
Just
my name
state-
is Greg
yeah.
Robinson. I'm an abutter to the roadway in here, and I have not and did not receive a notice of this meeting or any plan.
You in a butter?
Yes,
Direct abutter?
yes. In fact, my house is the closest to this roadway if it ever becomes. That's why.
How
I
long you
object.
lived there?
20 years.
You have that list on you? Should it be online?
We don't have the cards in this folder.
The applicant is notifying the abutters now.
Now? Okay,
Yep.
But we did not
I know.
have any notice of this meeting or the fact it was being held.
okay.
I only got it by word of mouth.
How about prior meetings?
All right.
The last one, yes.
Yes, Matt, sir, just keep it to us. Hold on a minute.
The fact that he's here indicates that somehow he was notified.
Which I understand, but I still would like
I
to... see-
understand, we might
Yeah,
want to
we have to submit these ahead of time, so it's
Right.
already,
I was
mean, I can,
notified by word of mouth from
Right,
everybody.
1 minute, please. Just FYI, from now on, you gotta let the applicant know, they're gonna, every hearing, they gotta bring the cards to us and the list, and we have to check them. Did you check them?
I think she's got him in front of her.
yeah, so this, I submitted this to Sonia right after we sent
They
it.
should be online, it should be posted
Yep,
online.
Raymond and Patricia Robinson, 79 Pine Lane, Osterville. So the address that's, we get from the assessors
Right.
are, that's
Do you have
where
a
it was sent.
Nosterville address, sir?
No,
So that's from the assessor, so whether it's on the deed or something, but we don't
Is
get
it
those.
the same
addresses.
name?
Yeah,
That's weird.
Patricia and
there is a
Raymond.
couple with the same name in the area. I
Oh.
only found out at my bank one day.
Is that true? Okay. All right, well, nothing. All right, well, you're here, that's what matters for right now. But we will check on that, but for future, we forget that the applicant does these things, we have to go through these
But
things.
you have an objection, you haven't stated it yet, other than
Right.
the fact that you weren't notified.
Well, I don't know any details, so I stated objections at the first meeting about the traffic on the roadway in, and I still hold that.
Okay, you were here in the first meeting, you were about traffic and all that.
And I'd like to make a suggestion.
Yes, go ahead.
Which I think would make it passable.
Sure,
I mean, the objection was made for opening up the roads to Main Street
right,
for the fire engine. Because nothing will stop the fire engine coming in or from the top. I mean, if there's a fire, the fire engine's going to go wherever he wants to go.
correct.
I still would feel happier if the tenants that are in here, when it's finished, exit and come in from Main Street. I really don't want all that traffic going 10 feet away from my bedroom wall, quite frankly.
I totally understand. Our, going on Main Street, being a steep driveway, our bylaws allow so much of,
The
like,
objection was only made at the first meeting for the fire engine, and that's understandable.
I understand, but you can't have a driveway that's steep. I think we have a limit, I don't want to say 1%, 2% on driveway. Especially in a commercial project like this, you can't have it too steep, like somebody coming down, it's icy, slamming the brake, before you know it, they crash into somebody, or you have a rear-wheel drive car going up in the snow. I know for a fact in the rules and regulation on subdivision, you can only do so much of a pitch on the driveway. I'm not sure, but we will take this in consideration until next time, and we'll see how far it gets. And it's not getting that far tonight, but eventually we'll discuss this matter.
Thank you.
Thanks for coming. Sorry about the confusion. All right, Counselor?
Thank you, Mr. Chairman. Attorney Mark DeShays, representing the trustees of the Emma Louise Reed Irrevocable Trust, a direct abutter to the project. I submitted a letter tonight that procedurally, this can't be heard tonight. It does not follow the mandates of General Laws, Chapter 48, Section 16. Specifically, a reconsideration of an application has to be initiated, and I have the statute here, after the consent of the planning board. The statute is very clear. Once there's been an unfavorable action taken, any reconsideration has to be and go through Chapter 40A, Section 16, if there is a substantial and material change in the conditions. There has not, assuming arguendo, that there was a change in the conditions, which there are no conditions here. To reconsider it, you would have to initiate the action with the planning board, giving notice, as my sister says, Mr. Bobrowski sets out quite clearly in his book, Land Use Planning, that the planning board has to give notice to parties in interest of the proceeding at which the consent will be considered. You have to have all but one member of the planning board consent to the application for reconsideration. Then you, as the special permit granting authority, must give weight and find on the record that there is a specific and material change that has occurred, and you have to say the change in the record. There has been, this right-of-way has been there. It doesn't matter if you have an ownership interest or, that's irrelevant. There is irrelevant. There's a right-of-way, there's a means of access to get to the property. There's nothing substantial or material that they have acquired, and when I last checked, there's nothing at the Registry of Deeds indicating that they have acquired this. I am saying that procedurally, this matter is not properly before this board. And even if it was before the board, you would have to find something material and substantial to open it up. What this is just an artifice for you to try to revote something. You are governed by Massachusetts general laws. You can't willy-nilly just turn a blind eye to it. The statute is very clear. Something that has been unfavorably and finally acted upon. This board, at the November 8th meeting, closed the public hearing. There was a motion to approve the intake of testimony. You heard from the petitioner, you heard from the opposition. You closed it. You opened it for discussion. There was a vote taken. There was 3 in favor and 2 abstentions. It failed procedurally. There was no conditions attached to be reconsidered. This was a final action. Shortly after that, on your website, this was considered to be a closed matter. All the information has been taken off, and it wasn't there as of yesterday. The reason, and I think that's probably correct, because quite frankly, you have no authority to consider this tonight. It's as simple as that. There's not, you have bylaws, but the overarching governing is the Massachusetts general laws. I've cited it in the letter that I submitted. You are wholly without power to open this and reconsider a vote that failed on procedural basis. There was no decision.
Okay, let me ask you a question, just clarification. Do you feel, Counselor, I do agree with you, the procedure matter, but say, can Counselor Moore and come back with an application
2 years.
with the substantial changes or a different applicant? As far as I understand, if it's a different applicant or different owner or substantial changes, she has the right to come back with a different application. Don't you agree on that?
I don't quite understand your question. here.
So if she is, I understand with the procedures you talk to right now, and I do agree with you. It's not the reason it's not a planning board because it required the variance. Let me finish. I'll let you finish. Let me speak. When it's a variance, it becomes a one-stop shop with zoning board. The board becomes this granting authority of the special permit, site plan, and the variance. That's why it became to us. In this matter, this is general language that it goes to the planning board, but you cannot appeal our decision to the legislative board. They are a legislative board, more of it, that's what they are. So you can't go to them on appeal. You understand? So if you're appealing,
I didn't write the statute. The legislature, and it's written, it's not, it says, "and unless all but one member." It talks about...
correct, that's four,
It
because
talks
we are
about-
5 members, I understand, you need 4
It
members.
cites 2 things: the special permit granting authority, which was you,
Correct.
or a permit granting authority. So it's got both of them. But it says, "and unless all but one of the members of the planning board consents thereto." This is under what they call repetitive applications, and you're barred for 2 years.
That I understand, but
It's right there. It's a conjunctive. "And unless the planning board consents." It doesn't matter that they weren't involved at any point. The statute says you gotta go to them first. It's gotta be initiated with them.
I
Not with you.
can't answer that, to be honest with you.
No, but Bobrowski answers it. The statute basically says, "and notice, and unless all but
Mr.
one..."
Bobrowski says if it's a zoning board permit or any permit.
There's one case, it's an Edgartown case on point.
So he's talking about that one case, Mr. Bobrowski?
That's the one case of appellate law.
Right, was that case a planning board permit or a zoning board permit?
I don't have the case right in front of me. But it doesn't matter. The statute basically says, "and unless all but one of the members of the planning board consents thereto." And after notices and they give the notice. You just can't rewrite Mass General laws.
No, we're not, and we're not trying to, believe me, and we're trying, okay, just bear with me. Your comments are based on that case law or on the Mass General Laws 48, Section 16? Is that based on the case law or in the general laws?
It's based on both.
No,
Mr. Chairman?
No, it can't be. Can't.
Yes,
Mr. Chairman?
The case basically sets...
One second, Ken. Go ahead, sir. Okay, let's listen to Mr. Yes, Kenny.
Section 16 of the of Mass General Laws, Chapter 48, does not specify that what it says is the special permit granting or permit granting authority shall be acted favorably upon within 2 years of the date of that unfavorable action, unless said special permit granting authority or permit granting authority finds by unanimous vote of the board of 3 members or by vote of 4 members of a board of 5 members or 2/3 vote of a board of more than 5 members, specific and material changes in the conditions upon which previous unfavorable action was based. In other words, it doesn't say that the planning board has to take action on it. This is action that is taken by the Board of Appeals.
Correct, thank you. So that's exactly what I'm talking about. I believe this matter,
I have the statute, and you can't, there's a comma, and then it says, "and unless."
yeah.
Thank you. I know. I got it.
So so you printed this from chapter 48? Well, guess what? We're not gonna be able to decide on this with our council, I guess. Our planner say one thing, you say, and I don't doubt what you're saying. But we put this aside, we'll get back, we will get an answer on this.
If I may?
Yeah.
I listened to council, I listened to you. I suggest to this applicant and this board that this application be withdrawn, and that if they want to come back to us regarding this property, they come back with an entirely new application for an entirely new project.
It can't be
Either under
withdrawn.
either a new owner. I'm not asking for you to interrupt me, I never interrupted you, sir.
Our clerk believes, and I believe, if you come back with major substantial changes on the application, you don't have to wait the 2 years. He suggested that the councilor withdraw. In the meantime, we'll see what the board says, and in the meantime, we will research that and get back to you. Go ahead.
Mr. Chairman, I draw your attention to the second part of Chapter 48, Section 17. It may be withdrawn without prejudice prior to the publication of notice of a public hearing thereon. Again, it wasn't withdrawn before the public hearing, so, read the statute.
If I may,
Yes,
Mr.
go ahead.
Chairman?
Yeah.
So I would ask the board to allow this to continue. I received this at 5:40. I am well aware of his argument. I don't agree with it. I think we do need possibly counsel. But I don't think him telling you that you don't have authority to hear this reconsideration, and there needs to be research on this. We're of the opinion that there is a substantial change that was the reason for the abstaining votes. So, just to give us time to be able to respond to that, you do your research. But to make some sort of determination tonight, I don't think would be wise.
Great, I like your comments and your idea, and I do agree with a lot of it. And I think we should talk to our council before we talk. Before making a decision. It's only fair to you, to them, to everybody. If council says you're right, then you're right. If he says doesn't matter, doesn't matter. We'll see what he says. We're not attorneys, so we can only go so far before we hit the wall. And I'm not personally willing to make a decision on this.
I make a motion to continue.
And if you don't mind, Jim, before we make the motion to continue, we want to hear the rest of, is that, Council, you want to say anything? Well, your comments are taken, we'll review it, we'll see what happened. We'll get back to you next time. Okay.
Maybe my motion's premature, maybe there were other people in the
Right.
audience that wanted to speak.
Is there anyone in the audience that the councilor don't represent want to speak against this matter? Okay, I guess he speaks for all of them. Councilor also, Attorney Moore, and in that cease and desist, you get a major problem with that project.
Yeah,
I mean,
I'm not denying what you're
I
saying.
don't know what to say. That's probably your major changes. You gotta knock off a building. You're now down to 2 and make a 5.
Yeah, or just build the 15 units. and
I'll
withdraw.
come back for 11, or,
Yeah,
yeah.
whichever. So there's a lot to consider.
Yep.
I strongly recommend that cease and desist And I don't know what the fees on it or the violation, how the commissioner assess it. That's gotta be addressed, but until now, like as of today, I think the board stuck until we have an answer from council and from everybody else. Council, you wanna add anything before we go? Send you home. Great comments. I mean, it's something to learn and something to know for next time, but like I said, we'd like to run it by council. Yes, sir. Yeah, of course you can. Come forward. Have a seat and state your name, sir.
Thank you. My name is David Warr, and I live at 184 High Street, which is sort of across the street from that driveway.
Yeah.
And I did receive notification of this meeting, but I was not party, or did I attend, or was aware of previous ones. I think my question it's a very broad question, a very general one. Can you tell me what is the issue? Is the issue whether this access road that's been used as a driveway is of adequate size?
Well, right, to be honest with you, right now, this is not what before us.
Okay.
So there's no sense discussing it.
Okay.
But let me, is Abara to Abara, is the road in Abara? Is the town?
The town, no, but
Even across the street, you should have got notice.
I think I did get one of this meeting,
Oh, you did,
but I
okay,
didn't get
Okay.
any of the others.
Any of the others.
Yeah.
right. So the town doesn't, so Abara to Abara or 300 feet.
I think to answer his question, and if I'm,
Right, okay. So, and the town property doesn't, you don't add the road as an Abara? Okay, very well.
but the road doesn't interrupt in a
Okay, all right.
contiguous point.
So anyway, to go back to you, sir, this,
To answer his question, if I might.
yeah, go ahead.
To answer your question is, what's the problem?
Right.
And in general, and if the board disagrees with me, they can correct me, but in general, the board found in favor of the project, but the project was opposed because of the access, and the opposition was based on the overburdening of that right-of-way and whether or not, and members of the board were unable to make a decision based on that information, and therefore they didn't vote in favor or oppose. They abstained, so there weren't enough votes to approve the project. That's where it sits right now. If that's wrong, somebody correct me. Does that answer your question?
Bless you.
I think it does.
Okay.
I think so, and I appreciate the time.
Okay,
Very
thank
well.
you.
Thank you. Okay, that being said, let's get a motion to continue.
So moved. January
mo-
24th.
Do I have a motion to continue till January 24 by Jim? Do I have a second?
Second.
Second by Rich. All in favor, say aye. Roy?
Aye.
Veronica?
Aye.
Jim?
Aye.
Rich?
Aye.
Myself, Nazir, aye. We have to vote at the end of the hearing, send a vote that we need assistance from council to the selectmen.
Yes.
Otherwise, they won't let us talk to
Yep.
him.
Yep.
All right,
You want to take that vote right now, quick, because it's pertaining to
yeah,
this?
sure.
I make a motion that the board seek
Assistant?
seek assistance from town council regarding this matter, and that the chair be granted permission via the selectmen who feel they are entitled to make the decision whether or not we can talk to town council to do that. So this needs to go, we need to vote, we need tonight to vote to send this to the selectmen and have the selectmen decide whether or not we can talk to town council
Yes.
on a
That's-
policy
That's a new policy they have.
policy that was just sent to us this week, effective January 3rd, 2023.
Okay, do I have a second on Jim's motion?
Second.
Second by Troy. All in favor, say aye. Troy?
Aye.
Veronica?
Aye.
Jim?
Aye.
Rich?
Aye.
And myself, aye. So, can you type something for us, one of us, and send it to Selectmen? Thank you. All right.
So
thank
wait a
you.
minute, now that I say that, now that we voted on that, if we have to get the permission from the selectmen to talk to town council, that might add a couple weeks to this process. Do you want to come back on January 24th, or do you want to come into February?
If we may, I was going to suggest that, and I'm not here the first meeting in February.
So you want the second meeting in
Yes,
February?
please.
So I'd like to alter my prior motion that we voted on for January 24th, and I'd like to amend or credit or unvote or whatever we have to do to bring them back in February instead of January.
So that'd be February 21st,
28.
28th?
February 28th?
Yes. Whoever's here for this matter won't be sent another notice, so make sure you show up on February 28th if you wish to hear it. Yeah, that's probably a good idea, because I guess town council didn't feel good.
So do we want to revote that officially? So moved.
So for February 28th, continuing 21-23 for 386 Main Street. Do I have a second on that? Second by Veronica. All in favor, say aye. Troy?
Aye.
Veronica?
Aye.
Jim?
Aye.
Rich?
Aye.
And myself, Nazir, aye. So for the 28th.
Thank you.
Thank you.
Jillian, you sound like you're getting worse as the night's going on.
I had court this morning too, I lost my voice, so appreciate you holding out.
You gotta follow up with that matter.
She knows.
All right, 55-23, Jeffrey and Amanda.
Anything coming in on that last one? Did I hand anything out? I don't think I did.
Oh, look who's here. Mr. Botello's here.
What's this, 5523?
For 16 Widows Cove Lane.
Are you guys gonna be trouble now? I gotta move this in. You
Gonna
can't
want
answer. Don't
waivers on
answer.
everything.
The Zoning Board of Appeals will hold a public hearing on January 10, 2024, at 6:30 PM in Room 320 of the Wareham Multi-Service Center, 48 Marion Road, Wareham, Mass. 02571, to consider petition number 55-23 for a special permit and/or a variance, thumb requirements of Article 6, Section 621, and Section 625, and Article 13, Section 1352 and 1353, under the Wareham zoning bylaws to Jeffrey Johnson and Amanda Cutt, care of Bradley Bertello, J.C. Engineering, Inc., of 2854 Cranberry Highway, Wareham, Mass., proposing to complete renovation of the structure, including a proposed 5-foot by 26-foot front porch, proposed 1 1/2 feet by 13 feet, first floor addition, and a proposed roof line for second floor expansion that are being constructed on a pre-existing, non-conforming structure in the side and front setbacks. Also proposed is a 12-foot by 16-foot shed located in front of the principal structure, located at 16 Widows Cove Lane, Wareham, Mass. This all appears on Wareham Assessors Map 22, Lot D8, in the R60 zoning district.
Very well. Name and address, sir.
Good evening, Brad Bertolo with JC Engineering. With me tonight is the property owner and applicant Jeffrey Johnson. I see that you guys have a full-size site plan. If I may, I have some visuals that'll help out to show the work to the house.
Yeah.
Thank you.
Thanks, Brad. I do better with pictures than I do with words. Thank you.
All right.
So, as was stated in the public notice, the property owner is looking to do some house renovations to this existing dwelling. The dwelling is located in the R60 zoning district, requires 60-foot front setbacks and 20-foot side setbacks. The existing house extends as close as 36.6 feet to the front property line and as close as 10.7 feet on the left property line. The right side property line, we have more than adequate zoning setback requirements. So as part of the project, we are looking to, the property owner is looking to construct a couple small additions across the front of the structure and add a proposed porch. Those expansions are within the 60-foot zoning setback, but no closer than the existing house, which is at 36.6. The proposed expansions towards the street extend as close as 50.1 feet attached to the house. As part of the project, he's also looking to expand the roof line to expand the second floor over a portion of the house. I did submit architectural plans in the application, but what I just handed out to you today is a better picture, highlighted the areas where expansion is taking place. So those areas that are highlighted in red show the minor changes that are taking place. The house has a higher two-floor section, and they have a second floor with a smaller roof pitch at this time, so they're looking for a full second floor over a portion of it. That expansion is within 20 feet of the zoning setback line, so because of the increased height, a special permit would be required for that aspect. So a special permit for the increased height on that portion of that second floor addition, and a special permit for the additional footprint that extends closer or is within the 60-foot front zoning setback. As part of this project, the applicant would also like to construct a detached accessory structure. The site plan we have is 14 by 14 as opposed to 12 by 16. Situated in the front yard, and in the zoning bylaws, accessory structures can't be any closer to the street than the main structure itself. So that would require a variance to do that. We feel we have a pretty good case in that because the property is fairly unique, being adjacent to Onset Bay. It has a number of resource areas or buffer zones in the rear of the property. Pretty much the whole northern portion of the property is within flood zones, some velocity zones, some AE zone. And there's also septic systems located just northerly of the existing house. So construction of an accessory structure in those locations would require additional structural support because of being in a flood zone and additional permitting through conservation. We feel that it'd be more feasible to construct a structure in front of the dwelling, put it outside of the flood zone. We have it tucked away in the lower right-hand corner of the property. We're not getting any closer than 20 feet from the side setback, which on this property there is a 20-foot easement, so no work's being performed within the easement. Tucking it behind some existing vegetation that's there today. And this situation very similar in this neighborhood. The abutting neighbor to the west has very similar situation. They have a detached structure in the front of the property. This roadway is a small cul-de-sac, approximately 3 or 4 neighbors, or maybe five total houses on this cul-de-sac. And on this dead-end street, there's only really two neighbors that really access the end of this property. So we feel that it wouldn't be a detriment to grant a variance for the installation of a shed, which is going to be a residential shed used for their typical lawn maintenance equipment, yard furniture.
Paul, is it R30 or R60?
It said in the public notice, it said 60.
60.
I don't know, if you want to pull, I might have a copy of the zoning map here, I might be able to look quick.
Field card says R60.
R60, the field card?
Field card, and they get it wrong on the field card sometimes, but I think it might be 60.
I do have the map.
You got the map?
Yep.
I think I got the map, I got a map right here.
I think it used to be 30, changed to 60.
On the website, it says 60.
Okay.
This is a 17, we want the 07, right?
Yeah, also.
Yeah, this is a 17 zoning map.
Brad. Point it out, I don't even know where it is. Okay. It's 60, there's a mistake on my letter.
It's 60?
All right, very well. So one thing at a time. On the side setback, so under 1352, we could grant you a relief, and if the board don't feel so detrimental, we could act upon it as a special permit. On the addition, the roof line, all that stuff.
Yeah, it's not the height of the roof, it's just that the fact that it's within the side setback?
It's increasing a non-conforming structure within the setback.
Because it's a setback, not a height issue.
Yes, so theoretically, it'd be the first 10 feet of that structure, between 10 feet and 2 feet of the addition, because the rear of the house is 18.3 feet. So at the 20-foot setback line, actually in that area, we're decreasing the height, because there is a portion of this roof line coming down. They're changing that roof, that gable roof to a flat roof to provide a porch. I have that hatched out in gray on
Yeah.
that map. That's the actual roof area being removed and lessening in height.
Are you putting new foundation too for that? You don't need,
No.
just going up?
Just for the footprint expansions in the front of the house. That's the only foundation work that would be necessary.
All right. Before we go, yeah, let's deal with this before we go to the shed. Go ahead. Troy, what do you think, before the shed?
Excuse me, Chair, and it won't be a foundation, it's just gonna be the sono beams, it won't be your full standard foundation for that addition. That's going to be filling in what will be the front.
On the porch?
Adjacent to the porch, there's kind of a dead area that's been
Yeah,
molded
that
and
little
going to
dead
be
area.
used.
12.3 times 8.8?
Yeah.
That one, okay. All right. So you're just gonna close it in between there and the garage?
It's
Yeah.
kind of a
Garage
quirky
is still
design.
closer than what you're adding. The
What's that?
garage, if I saw the pictures, the garage is still
The garage
close.
comes up 20 foot.
Yeah, you're still set back, yeah.
Troy?
I don't have any questions.
We're just doing on the house, we deal with the
Just
shed
the
in a
house, yeah.
few.
No
Just the
problem,
house? I don't have a problem.
Okay. Jimmy?
no problem with the house.
Richard?
No problem with the house.
The only problem I have with the house is that you own it and I don't.
We're very fortunate.
All right, and on the matter of the house addition, anyone on the audience want to speak in favor or against? I hear none. All right, going back to the shed. Why you can't put it in the back? What's the reason? You got room?
It's all located in flood zones, going to require additional structural supports being constructed in a
I
flood
guess
zone.
this is flood zone back here. Elevation-wise,
It seems to me like the front of the house, you can put it on blocks, you put it in the back of the house, you gotta anchor it down, right?
Yeah,
it could float away in the back, and if we put it out front, it might stay there with a couple ground grabber screws.
That location, ideally, and anybody on the board has been down there, there's a large, very large pine tree that would essentially cover the structure from the road. Not to mention, there's other bushes that are that are there.
Can you speak to the mic so you
Oh, I'm
on
sorry.
record? That's all right.
I apologize. Yeah, there's, the current location, and part of the reason why we did it is to, in an effort to work with the neighborhood and to continue with the bylaws of not having essentially an accessory structure that is on top of the road. I purposely picked a location to hide it behind what's currently 2 large pine trees, and then there's some bushes and other plantings that are already in that location, so making it nearly invisible from the road.
Troy, what do you think on the variance?
I don't see, I mean, I like the fact that the bushes and shrubs and everything are gonna cover it. I don't think that it's all that big of an issue, based on the backyard where they couldn't do it at all.
Veronica?
I agree with Troy.
Jimmy?
I have no problem with it.
Rich?
I don't have a problem with it, because it looks like the hardship would be the topographical backyard, the way it pitches, and plus the flood zone area, so.
That sheds new light on it.
Anyone on the public want to speak in favor against that shed? Or on Zoom?
Okay.
All right, I hear none. That being said,
I make a motion to close the public portion of this hearing.
Brad, you want to add anything before?
No.
No? So we have a motion to close by Jim. Do I have a second?
Second.
Second by Rich. All in favor, say aye. Troy?
Aye.
Veronica?
Aye.
Jim?
Aye.
Rich?
Aye.
And myself, Nazir, aye. All right, we're gonna go with the variance first to construct the sheds.
I make a motion to grant a variance
To
for the
construct
shed
the
to be,
shed.
for the shed to be located as shown on Plan D 2.0, oh no, on Plan, proposed site plan 16 Widow Coves Lane, Wareham, FGS Design Group, dated 2/6/23.
12/6.
12/6/23.
12/6. Said two. 12/6/23. Okay, any discussion on the shed?
6/23.
Maybe not taking down the shrubs down, keep the shrubs, make sure, I'm sure they will, but replace them if they die.
It's a nice, big, beautiful pine trees that are really gonna be the main portion that's gonna be blocking it. They're 30, 40 feet high already, and there's no intention.
All right, any discussion on that?
We could
No?
put a, say that the foliage blocks the view of the shed from the street.
Okay, that being said, so do you have a second on Jim's motion?
Second.
Second by Troy on the variance, and the motion to grant shed that meets statutory requirement, chapter 40A, section 10. Second by Troy, all in favor, say aye. Troy?
Aye.
Veronica?
Aye.
Jim?
Aye.
Rich?
Aye.
And myself, aye. So Nazir, the shed carries. Going to the house, what's the wishes of the board? You think it's substantially detrimental, you want to go?
I
for
move that it's not
special?
substantially detrimental to the neighborhood and that we should be allowed to vote on it as a special permit.
Okay, that's Jim's motion. Do I have a second on that?
Second.
Second by Troy to act on it as a special permit. All in favor, say aye. Troy?
Aye.
Veronica?
Aye.
Jim?
Aye.
Rich?
Aye.
And myself, Nazir, aye. Now on the special permit.
I grant relief as requested as a special permit. Same thing, per plans, on the correct date. 12/6/23.
12, okay, drafted by GC Engineering, apparently. All right, and findings are not so detrimental to the neighborhood, no substantial detriment to the neighborhood and standard condition. Do I have a second on that?
Second.
Second by Rich, all in favor, say aye. Troy?
Aye.
Veronica?
Aye.
Jim?
Aye.
Rich?
Aye.
And myself, Nazir, aye. Carries. Thank you, good.
Very much.
Thank you, both.
Thanks. Have a good night.
Welcome, Mr. Botello. Brotello.
Bertolo.
Bortello. Well, all kinds of waivers, huh?
At least he's smiling. The other night you were here, you weren't smiling.
All right,
That's all right. Your face won't crack, don't worry.
okay, can I have this
But
back?
I might make a wisecrack, you know? Can't help
All right, buddy.
myself.
All right,
Have a good night. Thank you.
last one. So that's 500. Okay, 56-23, Jennifer Noyes and Douglas Eifert. And that is for special permit or a variance for 24 East Boulevard.
You're lucky they've worn us down now. We want to get out of here, you know?
Yeah, well,
Maybe not.
that hard.
The Zoning Board of Appeals will hold a public hearing on January 10, 2024, at 6:30 PM in Room 320 of the Wareham Multi-Service Center, 48 Marion Road, Wareham, Mass. 02571, to consider petition number 56-23 for a special permit and/or a variance from the requirements of Article 6, Section 628, and Article 13, Section 1352 and 1353, under the Wareham zoning bylaws to Jennifer Noyes and Douglas Eifert, care of GAF Engineering, Inc., of 266 Main Street, Wareham, Mass., proposing to replace the wraparound porch with full deck and roofed at the property located at 24 East Boulevard, Wareham, Mass. This appears on Assessors Map 1, Lot 152, in the Onset Village 2 zoning district.
Okay, Mr. Madden?
I'm Bill Madden from GAF, here on behalf of the applicant. Also with me is Dana Ward, he's the contractor on the project.
Let's hear it.
Pardon me?
Let's hear it. What do you want to do?
Okay, we received a letter from the building commissioner relative to the wraparound porch that was torn off the building. The applicant filed a building permit application to remove the porch, and I think that work started in advance of receipt of the permit. And the resulting letter from the building commissioner was issued relative to section 1352 of the zoning bylaw. One of the things that, just like to point out in this house, it's a 1904 structure. It's been there since 1904. I didn't believe that there was any increase in any nonconformity of the structure due to the fact that the proposal was to replace the existing porch and roof structure in kind. So as part of the information that I provided with you, there's a couple of images of the house that show the wraparound porch on it and what have you. I happen to have the survey documents from the 1980s that indicate the location of the structure, which is consistent with the plan. So, you know, we're not increasing any nonconformity at all with the replacement of the porch. It's in the exact same footprint. I think that there is a little bit of a difference with respect to the foundation. The foundation is Bigfoot foundation. I'm not certain what the prior foundation was, but, you know, it was a situation where the porch in the building that was torn off was in pretty much disrepair. It had lived its useful life. It was taken down. There was probably another mechanism in which to do that work. You know, initially might have avoided this process, but it didn't work out that way. We're here before you on that. But in our opinion, I believe that we're not increasing any nonconformity. We're in exactly the same place as where everything was, and we're not expanding any square footage on the building. In fact, I think there could be made an argument, which I'll throw out there. There were side steps. You can see on the sketch that I provided you, there's some dotted steps that are on the, what side? The south side of the building. those are they're not going to be constructed at that location. The steps are going to be located off the front of the building, consistent with the access to the house. The front door of the house is on the front side. So realistically, we're removing a nonconformity where that step was extending over the property line. So we think that the removal of those stairs decreases the non-conforming nature of the encroachment in and of itself. The encroachment that exists, it's approximately 1.2 feet to the overhang of the deck. That's consistent with all the early survey information we have. We were not able to field verify it because the building had been taken down, but I placed quite a bit of reliance on the fact that I have all the original survey data that was associated with that lot when it was created and with the location of the structures located on the lot. So I didn't really think we needed to come before the zoning board, but respecting the letter from the building commissioner, who fulfilled the request, and are before you tonight, just seeking a special permit to allow the reconstruction of the porch and roof the way it existed previously.
All right, very well.
Question.
Yeah, go ahead.
Did the house get a new foundation under it?
No,
No,
That it was always a cement block foundation?
no,
under
it's
it?
cement block.
Okay, I was in the process, I
there might
thought,
have been I don't know what's taking place there, but I did, when I went out there and looked at it, I did notice there was a little bit of variation between the block and what have you, but it was no means a new foundation.
I didn't know if they had to tear the deck off to get to do the block work or something, that's all I was
Yeah,
wondering.
no.
Okay.
Well, for future reference, you do need a special permit or a variance from the board when you take something and replace it, if it's a non-conforming.
I went there to do a repair,
Did you say your name, sir,
Dana Ward,
and your address?
198 Club Valley Drive, East Falmouth. I went there to do a repair, and the deck was so deteriorated that I took it off immediately because I didn't want anybody to get
I
hurt.
do understand.
But I did I went and talked to Paul, and this is what we came up that we had to do because of the fact that it was close to that
Right.
sideline.
Our bylaw says if you wanna take something, replace it, and it's non-conforming or within the setback, you have to go to zoning board.
Right,
So
yeah,
regardless.
yeah. Well,
And
that's,
apparently, in your matter, you took it down, so you have to come for us. I understand it's unsafe, totally understand. But what the commissioner did is 100%
oh,
right.
I agree, that's what
Okay,
we discussed it.
let's go forward. Mr. Larson, Troy,
I don't have any questions.
Veronica,
No comments?
Jimmy,
No, I have no questions.
Richard?
Mr. Madden, I'm looking at these drawings, they're a little different.
Which one? The one with the other house to the right?
Oh, I'm just looking at the blueprints of the porch going on, that's all.
Oh, okay.
Just not used to seeing them like that.
That's right here, Jim.
But I don't have any problems with it.
All right. So, that being said, anyway,
About these?
okay, the structure ones. That being said, anyone in the public want to speak in favor of this matter? Anyone against this matter? Anyone on Zoom? Nobody. Commissioner, anything to add?
No issues.
All right. So in this matter, apparently, same idea, the relief from 1352, if the board feels not substantially detrimental, or we could do a variance, whichever the board wishes. That being said, before we close, Mr. Madden, would you like to add something on your client?
No, I'm good.
You're good?
Explain.
All right. That being said,
To close.
we have motion by by Jim to close the public hearing. Do I have a second on that?
Second,
Second by Veronica. All in favor, say aye. Troy?
Aye.
Veronica?
aye.
Jim?
Aye.
Rich?
Aye.
Myself, aye. Now what's the wishes?
Move to grant per plans, and
You want to give a relief, or you want to go
I want to
as
give him a
variance?
special permit. I move that we don't need a variance. Well, What do you think? You want to give them, you want to make it a variance and make it more official? I don't see the need.
No.
I think it's fine as a special permit.
Right, so we have a motion by Jim to grant relief for 1352 and act upon it as a special permit. Do I have a second on that?
Second.
Second by Troy. All in favor, say aye. Troy?
Aye.
Veronica?
Aye.
Jim?
Aye.
Rich?
Aye.
Myself, aye. So now it's a special permit. So what's the wishes on the special permit?
Move to grant.
We have a motion to grant special permit by Jim, being not substantially detrimental to the neighborhood with the standard condition and to be constructed per GAF engineering plans dated December 6, 2023. All right, do I have a second on that motion?
Second.
Second by Rich, all in favor, say aye. Troy?
Aye.
Veronica?
Aye.
Jim?
Aye.
Rich?
Aye.
And myself, Nazi, aye. It carries, thank you.
Thank you.
Thank you very much. All right,
Thank you.
let's go back on the minutes.
Before we do the minutes, how about, oh, the minutes, yeah.
We gotta beat our heads up with that.
I did
So-
get a chance to look at them.
So that, my question was why it was 400 and it was on the Onset Bay, and...
I think on the onset bay, I
I'm just,
abstained.
my question would be, is she didn't vote, can she just say she didn't vote, or should she abstain? So should it have been
I shouldn't
4-0?
have said anything.
So I was just curious, I mean, I didn't know
Did
that
you
you...
No,
say
'cause
it?
I thought of it that night when it happened, because I didn't vote, and then Nazi said my name, so I just said abstain.
Okay.
I shouldn't really have voted, it should be a 0 for me.
So it is.
Well,
for-
it was 400, so, but I just would think that if you were in present, it would be 401 if you weren't voting for abstain, but, I
No,
mean,
she
can we just not vote at all?
Yeah. No, well, she didn't hear it from beginning. I guess that's why you didn't vote.
That's why I didn't.
I understand what she said, but I'm just
It's
saying, that-
recorded as if she wasn't even present.
so should that be 401 or 400 with just an absolute no?
I think it's 0-0.
Okay, so then I don't have a problem with the minutes, and I'm good with them.
Sir?
I just wanted to say hello to Veronica, who was a former student of mine.
Oh,
Mr. Wallace,
Good heavens,
how are you?
nice to see you.
Likewise, very nice to see you.
Signed.
oh, 10 years ago.
It was, I think she said something about the class of 90-something. But I don't know if it started with a 19 or an 18.
Yeah, you know, it was, when you had the boatyard.
Yeah, well,
Oh,
That was-
yes. Yes, I remember that incident.
Long time ago.
What did you teach?
And it was
No,
prior
more
to
than
my-
that.
I teach chemistry.
Chemistry? Oh, so you know how to make a meth lab?
No, I have to do with the other kind of stuff.
That was 35 years ago.
That's 35 years ago, oh.
Yeah, yeah. Yeah, nice to see a friendly face out there. I always think of you when I drive by your house.
What? Oh, yeah.
Yeah.
We have
Fresh out of the egg.
The rules. But I think
A little undercooked, but fresh out of the egg. Said
Yeah.
I'm a little undercooked, but fresh out of the egg.
No, so your son and daughter, your daughter and
Daughter and son.
son-in-law, are they living here now? They living with you or near you? Nice.
Jan's a great cook, so she's out for me.
Oh, yeah. Nice.
we
Thank you
haven't
for saying
adjourned
hello.
yet, you can't leave.
I'm working Friday, I can leave.
You're working Friday?
Uh-oh.
All right, let's go back to the,
Must be freezing over.
go back to the minutes. So you guys want to vote on the minutes?
The minutes, I move to approve.
We have a motion to grant the minutes for 12/27/2023, and second by Rich. All in favor, say aye. Troy?
Aye.
Veronica? Rich? Jim?
Aye.
Rich?
Aye.
And myself, aye. The minutes are good, 500.
We still have the rules and regulations that we pushed off to the end.
Right. So, Since then, Kenny, you still there?
Yeah, I am still here, and I made some substantial edits to the rules and regulations. I think, but I don't think I sent it around to the board members.
I make a motion to continue this portion of this hearing.
Can you email it to us?
Yeah, I
Ken?
can. I'll do that now, so it's in your hands.
Thank you.
And I second.
Second to continue this matter, and,
All in favor,
okay, all in favor, say aye. Troy?
Aye.
Sorry about this.
Jim?
Aye,
Rich?
Aye.
Myself, Nazir, aye. What is
it's
it?
continued.
I thought we were closing I thought we were leaving, so.
No, we weren't. We haven't closed it yet.
Height of structure, didn't this come up when Onset came here with the marina? Oh, it's not on.
Height of structure,
The height of structure, was it, right,
the marina.
so correct me if I'm wrong, because maybe I misunderstood. The marina, the attorney argued that increasing in height does not increase a nonconformity.
Yeah, but they met the setback. See, they pushed it to meet the setback.
They put it within the setback, so that it was not
It
non-conforming.
was no longer non-conforming, right?
So we restricted something that they had the right to do. They were set back. If it was closer to the property line, then yes, it would be extending a nonconformity, but it was,
So I was under the impression that we voted to tell them they cannot,
and that's what we reconsidered, because we couldn't tell them that.
right, but what had come up was whether or not increasing height increases nonconformity. Remember that was an issue? and
Yeah,
he-
that was an
he
issue on
argued
something
that?
else, but on that particular issue, they were conforming.
I know, but, all
See
right, let's,
that,
but I'm just, so my question is,
If
does
it were
it?
close, if it
'cause
was,
that was never really answered.
you're increasing a nonconformity.
He argued that, and we said, I felt like it does increase.
we closed that public hearing, did we? Okay, go ahead.
I feel like it does increase in nonconformity, especially if it's
It's
a
not,
house.
it's not,
But it doesn't.
it's not,
You're saying
it's
it
not,
doesn't.
it's confirming now.
No, I'm
it's
not.
not.
She's
I'm not
saying,
saying-
in any
not
case,
conforming.
on a different case.
In any case.
not.
It's not conforming?
No.
The way it
No,
is?
I didn't
No,
think
it's in the
so.
50-foot setback from the residential.
Exactly. We approved it. Well, I didn't. Y'all did.
I thought they moved it within 50, they moved it back 50 feet is what we
They
were.
said we were wrong with our vote because we couldn't say that it was not.
But they
Height
didn't,
would,
Height
I
doesn't,
think the issue with the height is you have 1 and 2 family. Increasing the height, if it's in the setback and you're increasing the height, you're intensifying the nonconformity.
right.
A lawful pre-existing nonconforming structure other than a single or 2-family residential structure may be altered or extended, provided that the alteration
Tonight's side, yeah.
itself conforms to the current requirements of the bylaws.
So it could be a shed and they could do it.
No, let me finish this. So in that zone, you're allowed to go to 45 feet of height.
No, so I understand.
Oh, okay.
Yeah,
So
I'm
they want
asking
to-
for a regular, so I'm actually going just,
She's, in
you
general,
answered what I was asking. So if it's a house, you can't, because this one that came before us, I was like, well, onset, they said, the structure, but you're saying if it's not a house,
Correct.
it doesn't increase the nonconformity. So if it's a shed, it doesn't increase the nonconformity. They have the right as long as it's within the law.
no.
Yeah.
What do you mean,
that's
the
what that
shed?
said.
I don't follow the shed.
no,
Yeah.
he's.
A
when he
brand
says
new shed?
residential, he's talking zoning. When you're talking shed, you're talking structure. Am I right?
No, still
He's-
zoning.
So what he just read is that if you increase the height of a structure that is within, that's not conforming, right? And you want to go up in height, which is what happened with onset.
In a
As
residential
long as it
zone.
doesn't increase the nonconformity. So they did go from 33 feet to 40 feet, but it's allowed to be 45 feet legally.
Right, but
By
it's.
right.
Right, but it's not, according to the bylaw, increasing a nonconformity if it's going up and it's not a house.
Correct, there's 2 separate things.
Yeah,
Yep.
That's just what I wanted to, I didn't know, so
Yeah.
anything other than a
We missed
living
you too.
Right.
house. And is Jim correct in terms of where it is? Is that
Zoning?
just residential? Because that,
Commercially and
Or across the
residentially?
board.
Marine, it's marine.
It's in Marine.
okay, I need to clarify something, because I think I confused my question by bringing up onset. Let's pretend I didn't bring that up. Just in general, if a structure increases in height and it's
One or
not-
two family,
One or two family, it's two
one or
separate
two is
things.
separate. One or two, and everything else is separate. So one family or two families,
Other
everything
than-
else is separate.
This is
They're
under
different.
Said
section
other than
alteration or
one or two
extension
family,
of
right?
other structures. And then what you're talking about, I might perhaps getting confused, it's 1 and 2 family. So in front of that is all 1 and 2 family, then this 1360 is
Other
structures.
structures, yeah.
Other
Well,
structures, other than 1 and 2 family house.
So 5-unit building,
So a
that's not a
five-unit-
1 and 2
So a
family.
5-unit building is considered an other structure, and they can go up
Correct.
as much as they want?
No.
And
No.
up to
45.
45.
No,
law?
No?
no, it depends what that bylaw, in marine is 45, if you in
No, that's what
MR
I said.
30, 35,
Right, up to the law,
up to the,
Right,
yeah,
yeah.
the bylaw.
But they happen to be 45 feet.
right.
Yeah.
Okay, thank you, that clarified that.
And going back to the marina, that marina probably existed before 99% of the neighbors bought their property, and that was the zoning then, too. You know, it always galls me when somebody buys a house, and then they want to change what the neighbor's doing, and they're doing it by right.
That
It's not
marina
by
is-
right. It's
is-
not really
has
by right.
expanded and
Well, if the zoning,
expanded.
if it's 45 feet, you got no right to say you can't, you
Right, but they still need a special permit.
that, I'm not, that's not, it just,
But,
I go back to the Hingham Naval Air Base story, and it just bothered, you know.
I don't think that's accurate, though, Jim, about that marina, because that marina, when they bought their places, that marina was a small marina. It has increased how many times?
No, those warehouses been there
No,
forever.
right, but there are a lot more boats, because they have a lot, they've taken up a lot more of our harbor. Please, don't get me
That's-
started on
that's
that.
irrelevant.
It's aggravating to me.
That's
because-
irrelevant.
That's just,
No, but it's not really irrelevant to what Jim said, which is they were there first and everybody
no,
else wasn't.
it's not that they were there first, it's that the zone, it was an existing business. So if I'm buying next to a junkyard, and there's 3 cars in the yard, and then they put 3,000 cars in the yard, and I go down to town and find out that they had every right to have 3,000, just because there were only 3 cars,
That still doesn't
when
mean I
I
wouldn't
bought
be
next
mad.
door, doesn't mean they're restricted to 3 cars.
This is correct, but it still doesn't mean I wouldn't be mad.
You could be mad, you could be mad, but being mad doesn't make you right. Being offended doesn't change the law.
Oh, yeah, I
Which is
didn't
the-
say that
you
they
know.
were right, but,
Yeah? He's pointing his finger.
Yeah?
huh? But what's right, but what they're allowed
My
to do and
feelings are
what's
hurt,
right
but that
is not
still
always the
doesn't mean
same thing.
you know,
That's true.
this isn't the feel-good board.
Oh, it is when you
Good.
tell your stories, though,
Huh?
Jim. When you tell your stories, I feel good.
Yeah.
Once in a while, we are, Jim.
Whoever's watching, we need associate members.
And are we gonna close our meeting?
We
by
could
the way?
use two associate
Hingham,
member.
up in Weymouth.
Please tell friends.
I got a story. You can't close yet.
Okay.
Up in Weymouth, Quincy, when I was a little boy, we'd drive up to see Grandpa and Grandma. On the Route 18, I'd look over and I'd see this big, huge black building, and out front of it was parked a blimp. And those blimps were used in World War II, and we all, you know, and that was the Naval Air Base. So I got talking to my grandfather about it later in years, because they closed it down. And here's the story behind the Naval Air Base. A pig farmer owned the entire parcel, from highway to highway, town board, I mean, it was a huge parcel of land. And the Navy came along and said, "Hey, pig farmer, we want some of your land to build an air base." He says, "No, don't take my land for an air base. I'm a pig farmer. Next thing you're gonna be complaining about the smell of my pigs. That's why I have all this land, so that I won't bother anybody." And they said, no, Mr. Pig Farmer, don't worry about a thing. You're not, we just wanna land a few airplanes and park a few blimps. We're not gonna complain about the smell. So, and he says, if you don't say yes, we're gonna do it by eminent domain anyway, so, So he said, okay, I guess I'm just a pig farmer. So they built their air base, and they came back to him and said, hey, Mr. Pig Farmer, you got all this land, and now we built this naval air base. We need a place for our people to live. He says, hey, what are you doing to me? You're closing in on me. You're gonna start putting houses next to my pigs.
Then you're gonna
No, no, no,
complain
no, no.
about the smell.
It's okay, because they're gonna be working for us, and we don't give a shit if they complain about the smell. That's where they live, or they can go live somewhere else.
Yeah.
Oh, okay, I don't have much choice, do I? No, you don't. Okay. So they built all the houses. All the people moved in, they went to the town, and they said, who in their right mind ever allowed a pig farm to be so close to a residential neighborhood? And they shut the pig farm down. And that's the truth.
Man, was that one of your longest stories?
That's the
I
truth.
was wondering when the punchline was coming.
Well,
And he
so,
punched it too, he went just like that.
that kind of, I can remember my grandfather telling the story, and the
So you
reason my
think the
grand...
marina's gonna get shut down?
No, I don't think the marine's gonna get shut down, and I don't think it should get shut down.
I make a
I think when
motion to close our
When the
hearing.
people bought next to the pig
We have a
farm, they knew what
motion
they
to
were doing.
adjourn.
Second it.
Second by Jim. All in favor, say
Aye.
aye. Troy?
Aye.
Go.
Aye. Go.